I now recognize Mr. Moran from Texas for 5 minutes.
Thank you, Mr. Chairman. Mr. Ault, I want to start with you. Mr. Chenoweth was just mentioning this question I have for you, and that's about the ability for defendants to potentially opt out or remove these cases to Article III courts. That's one of the ironies of the administrative adjudication is the agency can actually choose to bring it in federal court and seek a jury trial. Would a defendant's right to opt out of in-house courts help address this imbalance? If so, how?
It certainly could. I guess my question is the devil being in the details, making sure that the provision which would permit for removal would be sufficiently automatic or easy, so as to preserve the rights. I mean, one of the things that I think we've all talked about is the degree to which the current proceeding, essentially stacks the deck in such a way that it exhausts the resources of defendants before they ever have a chance to see an Article III tribunal. So anything we can do to actually make it so that they can avail themselves at the first instance of an independent Article III judge would be a great improvement over the current process.
Thank you. Mr. Chenoweth, back to you on a new matter. We haven't talked about gag orders, but your organization, the New Civil Liberties Alliance, has raised a concern about gag orders and administrative settlements, particularly settlements involving the SEC. Would you describe for folks that are watching what a gag order is, how agencies use these gag orders and settlements, and why exactly it is that you have a concern with this?
Yes, absolutely. So there's a gag rule that the SEC implemented in 1972. It's one of only 2 agencies that we're aware of that gags folks who settle with the agency. They passed it as a housekeeping rule, and a housekeeping rule doesn't have to go through notice and comment, but a housekeeping rule also isn't supposed to affect anyone outside the agency. Obviously, the whole point of a gag rule is to gag the defendant, so it does affect third parties outside the agency. So it was unlawfully promulgated by the SEC. This was back when Bill Casey, I believe, was the chairman of the SEC during the Nixon administration. And so you have the Nixon administration wanting to gag people who settle with the agency. And then today we have folks defending that in the current administration, which I don't really understand why they're so eager to gag everyone. The Department of Justice doesn't gag anyone who settles with the Department of Justice. But the Securities and Exchange Commission insists on pain of settlement. In other words, they will not settle a case with you unless you agree to this language. And believe me, we've tried, and they won't do it. And the reason is that they don't want anyone out there criticizing the agency and explaining exactly what happened. These 98% of people who settle with the agency, they don't want any of those people to be able to talk to Congress or talk to the general public about what is happening to them, what they went through, what the deficiencies are in the SEC's investigatory and adjudicatory processes. And it's a very effective gag that the agency, that the SEC and the CFTC is the other one that has this, I should mention.
Well, it
but
seems
it's unconstitutional.
Yeah, I was going to say, it seems contrary to the very basic principles of the First Amendment that we are now gagging individuals so that they don't criticize government and government's overreach in their life. Would you agree with that?
I would absolutely agree with that. I mean, there are some rights that you can give up in exchange for settlement. You can give up the right to appeal, for example, as part of a settlement. But the First Amendment shouldn't be something that you give up. And certainly if you were in a federal district court, a federal judge couldn't take away your First Amendment rights as a part of a penalty against you if you were to lose in court. So if you go to court and win or lose, you still have your First Amendment rights. But if you settle with the SEC, you lose the right to speak anymore about your case. And some of the folks that we have as clients, sir, are in their 70s, 80s. They've seen co-defendants go to their grave, never being able to clear their name. And these are folks who they didn't do, if you got the whole story of what they did, you wouldn't think that they did anything that was worth going after at all, let alone something that they should have to wear as a badge of dishonor for the rest of their lives.
Professor Mascott, I want to come to you for the last question, and anybody else can weigh in after she does. But I'm curious about looking to the future. Where do you see red flags where this type of in-house tribunal might spread even further, either by subject matter or new agency, where we're seeing creep into other agencies to take away the rights of citizens to actually go to the judicial court system to get their claims adjudicated? Where are we seeing that? What should we be aware of, and where should we be watching?
Well, I think that as agencies continue to get more and more regulatory authority in more subject matter areas, there's just going to be more incentive to produce broad regulations and engage in burdensome investigations and then adjudicate these challenges within their own court system. So I really do think Congress should take a look at whether, now that we've had a few years looking at how this operates and have the Supreme Court looking at it, whether all of these questions of judicial review should be taken off the table by just requiring agencies simply to go into court in the first place. If the agencies have a valid rule and they're imposing it against the right people, they should be able to bring those charges in federal court without any problem, and it can solve all these questions of constitutional rights. I also think the solution is an interim matter of allowing people to remove from agencies to federal court could be a good one to look at. In addition, I think there doesn't seem to be any reason why members on both sides couldn't agree to requiring agencies to publish more rules about how they're, publish more information about how they decide they're going to bring charges and what procedures they use to bring these charges and bring the kind of transparency that we all have to follow here and in the federal court system. Thank you, Congressman.
Thank you, Mr. Chairman. I yield back.